defendant elects not to adduce evidence. And respectfully, all the material that is before this court in plain view, as I indicated, all the material is that there was an election to testify. There was an election to adduce evidence. And that was also included. That was also included. That's it. That election. Page. My lords, another significant passage in the decision in Biobio and Dramani is a passage at page 377 where, after referring to the English authorities, including Alexander and Reagan. Can I have back my? Yeah. Yeah. Okay. Where, after referring to Alexander and Rayson, in particular, the passage where the court had said that it is not right that the judge of fact should be asked to express any opinion upon the evidence until the evidence is completed. His Lordship, Justice Jateba, continues. Similarly, it is an inherently difficult exercise to ask this court, in this case, to disregard evidence put in place by the first defendant's affidavit and to rule on his submission of no case as if the only evidence on record is that of the plaintiff. That is why we consider that the interest of justice would be best served by hearing whatever evidence the first defendant wishes to offer in his defense. The interest of justice would be best served by hearing whatever evidence the first defendant wishes to offer in his defense. This court can then make up its mind in relation to all the facts at the end of the trial. My lords, respectfully, this wisdom of His Lordship Justice Jateba is particularly germane to this case, where it is the chairperson of the Electoral Commission is not only the returning officer, but in whose bosom resides the basis on which she made her declaration. It is in nobody else's bosom, not even in the bosom of your lordships. It's the law that is in your bosom, but in respect of the declaration, your lordships, it is only in her bosom that the basis of the declaration can be found. And so, where she has elected to give evidence before you, we cannot have a misapplication of Order 36, Rule 4.3 as a reason for her not doing what she has told us in a sworn affidavit she's ready to do. She cannot do that. The God to whose glory she announced she was doing what she was doing is a God of truth. And therefore, my lords, it is important to bear in mind what Justice Dr. Barnes said. And in this particular case, he actually goes on to cite what he calls the sound advice of Lord Justice Simon Brown in the Benham case cited above, where he says, "Let me state my central conclusion as emphatically as I can. Rarely, if ever, should a judge trying a civil action without a jury entertain a submission of no case to answer." That clearly was the court's conclusion in Alexander and Rayson, and I see no reason to take a different view today. The CPR notwithstanding, almost without, and that is a reference to the CPR, of course, in England, almost without exception, the dangers and difficulties involved will outweigh any supposed advantages. Any temptation, that's the last word, any temptation to entertain a submission should almost invariably be resisted. Now, my lords, it is therefore my submission the lordships are comparing. My lords, my respectful submission is that, exactly as in the Bill decision of the Supreme Court, the interests of justice, at a minimum, required this court to do exactly what was done in the Bill case.
Sorry for interrupting your submission. In that case, if my memory serves me right, we have come to court and made a submission of no case. And what we read was a ruling. In this case,
there's no submission of
yes, they are opting. It's an option. They are electing not to give evidence. So let us be very clear.
Yes, my lords. My lords, I'm very clear in my mind about what happened in the Bill case. I'm very clear in my mind about that. And I'm very clear in my mind that in that case, the plaintiff went to court seeking an enforcement of a provision of the Constitution in respect of the eligibility, exactly, the eligibility of an MP. Parliament. Yes. And my lords, in that case, as your lordship rightly said, there was a submission of no case. But my lords, the reasoning, the ratio decidendi of that case, in my respectful submission, is based on what the interests of justice require. Where a plaintiff has deposed to an affidavit, and in that case it was only one affidavit, and their lordships were saying, their lordships including your lordship, the Chief Justice, said clearly in that case that in the interest of justice, the defendant should testify. That's what your lordship said, and I'm respectfully submitting that that ratio is a ratio that is worth applying in the circumstances of this case. The only difference in the circumstances of this case is that they are relying on Order 36 Rule 43. And in my submission, that Order 36 Rule 43 does not lead to what they are arguing for, because...
Please, I want to correct this. They are relying on Order 36 and Order 38. Please don't leave Order 38 out, because Order 36 has nothing to do with witness statements. Order 38 is specifically crafted for witness statements. And you are avoiding that.
My lords, I'm not avoiding that. My lords, if your lordships are with me that Order 36 Rule 43 is irrelevant, then my lords, I will indeed address directly what your lordship is claiming that I'm avoiding. I cannot be said to be avoiding it when I referred your lordships to that Rule 5, and I said respectfully that the interpretation that your lordship was putting on that was not... I believe I responded to that. So how can your lordship on the other side say that I didn't respond, I'm avoiding 38.5? I responded to your lordship directly. My lords, I don't think it's fair to me to be making that sort of observation.
Another significant difference.
But my lord, can my position be accepted that I responded to your lordship?
You did.
Yes. So how can my lord say that I'm avoiding a particular provision? That's not right.
I just want to draw your mind. Another significant difference in the case we cited, the Bill case, is that dealt with affidavits. That dealt with affidavits. The court dealt with affidavits, which are generally evidence, because they are sworn. But in this case, we are not dealing with affidavit. So that is another significant difference.
My lord,
I wanted to...
My lords, with the greatest respect, that is why I took the pains to refer to affidavits that are before you in these proceedings. In the same way as an affidavit was before the court in those proceedings, I have referred your lordships to affidavits which are before you in these proceedings.
But these affidavits attached to applications.
Yes, but they are still before you. They are still before the court. My lords, I mean, affidavits attached to applications are before the court. Is that not interlocutory? That is why when people say affidavit, they say I refer to all the processes as if I included them in the affidavit. I mean, that is, I would have thought, the basic aspect of
in writing a judgment, in writing a judgment or a ruling,
yes,
would a judge be right if the judge went referring to affidavits attached to applications,
my lord,
and left the record of the testimonies and the cross-examinations that the judge received? Would you, in writing a judgment, would a judge be right, ever right, in referring to affidavits attached to applications that have been completed
Yes, my Lord, the judge, I not ignore. I never said that you should ignore. I said that you can refer to those affidavits. My answer to your specific, my lady, is that you can, for instance, if something that was in testimony is contradicted by something that she filed in affidavit, on oath, that is a matter that can be referred to, and that is a matter indeed upon which there can be cross-examination. There can be cross-examination on those matters.
That's mixing. That's totally mixing.
Totally what?
Mixing. If you have interlocutory applications and they're done with, you can mix them with the evidence taken at trial. You know that.
It's not a question of mixing them. You always have available a record. And if in that record there are affidavits in which statements have been made, they are on oath and you are entitled to refer to them. That's exactly what the Lordships did. In that Gabriel case, it had not got to what was stated in the affidavit had not been stated in the witness box. What was stated in the affidavit had not been stated in the witness box.
It's a trial on affidavits. In the Gabriel case, trial on affidavits.
We want to hear you. Just as the court ordered the defendant to go into the witness box, the court could have said, we want to hear your evidence in the witness box. Is your Lordship saying that you cannot refer to that affidavit which is deposed?
No, even in the affidavit trial, a deponent can be ordered to appear, to be cross-examined. So it's a trial.
That's what happened. But that is what happened.
Because that affidavit is evidence. So you can be cross-examined on it. But we are saying that in a witness statement, it is not yet evidence. That is where
my lords, I don't think the issue that we're dealing with right now should really be the issue of whether it is yet evidence. Because I believe
yes, that is agitating my mind. That is what's agitating my mind. But whether it is evidence or not, and the mere fact
that order 34 as cited by counsel is not relevant in the current circumstances. That's what you're saying.
Is that what your ladyship is saying?
No, that's what I understand you are saying.
That's what I've been saying.
Order 36.
And I believe that is what was summarized by your...
realize different members of the bench are agitated by different things.
And I'm seeking to address the different things.
Yeah.
And I appreciate the fact that your Lordship are candid with your concerns. I appreciate that entirely. And so, my lords, the point I'm making, if we move away from Order 3604.3, if we move from there into the question of what is the effect of a witness statement, which is what is agitating your Lordship's mind. What is the effect of a witness statement prior to when the witness actually goes into the witness box? And my lords, my submission on this is very straightforward. My submission of this is that your Lordships made case management orders in this case in respect of how the case would proceed, including the witness statements and the witnesses. Now, my lords, it is my respectful submission that nowhere in either your case management orders or in CI 99, nowhere is there provision made for the procedure that my learned friends are seeking to adopt. Nowhere in the rules. Nowhere in the rules. Now, your Lordships have been referring to Order 38.3 as amended in CI 87. And in that order 38 rule 3E, the provision again is very clear. If a party has served a witness statement and that party wishes to rely at the trial on the evidence of the witness who made the statement, that party shall call the witness if you wish to rely. That is why in my opening words, I said to your lordships, I said respectfully to your lordships, in my opening words, I said, this is not a situation in which counsel is seeking to withdraw the witness statement. I said that in my opening words. This is not a situation in which counsel is saying, I am no more relying on my witness statement or my answer. And 38 3E says, if you are still wishing to rely at the trial on the evidence of the witness who made the statement, you shall call the witness. Mandatory terms. Mandatory. You shall call the witness. They have not said they are not relying on that witness statement. They have not said that. So, shall call is mandatory. The last time I checked in the law books. And my lords, I'm sorry.
Lie, as you read.
Yes, but my lords, as that now, nobody has said we don't intend to rely on the witness statement. Nowhere has it been stated. All they have said is that we are not doing, my lord, that is the reality. I mean, however much grumbling goes on the other side, the reality is that ethics at the bar. Counsel is on his feet. He is addressing the bench. Please, please, please. You may take notes. You may hear him, but you don't have to make a noise at the background. Please, please, please. So, my lord, I mean, if they do not intend to rely on the witness statement, they should say so. It's as simple as that. If they do not intend to rely on the witness statement. My lord, yes, my lord, but this is important. My lord, this is important because there are many options open to us. If they say they are not relying on the witness, we can apply to the court for a subpoena to call the chairperson. For instance, we can apply to the court, yes, because
I thought it is implied.
The only reason why we did not take that course is, of course, because she is acting on behalf of the first respondent. So it would be inappropriate to issue a subpoena on the opposite party whom she is representing.
I thought it was implied by the application, by the nature of the application. I thought it was implied that you do not want to rely on it.
As your lordships heard me, from the opening paragraph or the opening sentences of my submission, I indicated what my understanding of what they had done was based on Order 36, based on, and I did not hear, and I don't think that your lordships heard any differently, I did not hear at any point a statement that they had decided not to rely on the evidence of the witness. I did not hear that at any point. And my submission is that unless they give an indication, and if they give that indication, then there are other consequences, especially in terms of our case. Because once they give that indication, then it is open for us, for instance, to have her subpoenaed to testify. As a public officer who holds certain records, it is open to us to do that. And my lord, this will not be contrary to any human rights of hers, because she has a constitutional duty that she is performing, and if she is called upon by a court to come and testify to the performance of that constitutional duty, that cannot be contrary to any human right. In any case, if, for example, there was an attempt to suggest that the witness had some privilege, or wants to exercise right to avoid self-incrimination. For instance, if the witness would have to give that indication, it cannot be assumed for her by anybody, least of all from the bench. It cannot be assumed that the witness has certain rights against self-incrimination, for instance, which she is wishing to exercise. Those are the human rights provisions, especially applicable in a criminal trial context. But whether or not they're applicable here, the witness is the one who has to invoke that particular claim of a privilege or right against self-incrimination or whatever. And that has not, as we speak, been the case that is before you. What is before you is Order 36, Rule 4, Order 38, Rule 3E and 5. I just read 3E, and clearly in my submission, until we have an indication that they do not intend to rely on that witness statement, and they then take the consequences of that, including consequences of what we are then able to do in terms of asking the court. The court may refuse it, but it would be entirely open to us to ask the court to take certain steps on account of what she said or what counsel says they are going to do. It is entirely open to us to take those steps after there is, if indeed that is the indication that is being given. Then I believe Order 38, Rule 3E5, I have addressed previously. So unless there is a specific question about any aspect of Order 38 that I'm not avoiding, so I'm happy to have my attention drawn to any other aspect that I've not covered. But I believe I have covered all aspects of Order 38 for 1B. Order 38, 3E and 5. Now, my lords, as I've indicated, and I believe there was a question from the bench yesterday about whether these are not issues of human rights. And I have an answer today. My lords, you put that into the arena yesterday, and so I think it's useful that I make a specific.
With all due respect. Yeah.
My lords, I'm not ignoring what your lordship say. I'm not used to that.
No, yesterday
I have a very well. Yes. Now, my lords, it is therefore my respectful submission that in the situation that is before your lordships, is for your lordships not to allow the evasion by the chairperson from cross-examination. And my lords, this is particularly important because of the nature of the function of this particular witness. We are not dealing with a witness in a normal civil trial, where it is simply a matter of competing private interests We're not dealing with that situation. We're dealing with a matter concerning the exercise of grave constitutional responsibilities by someone who has been duly appointed to a high office of state. And that person, in my respectful submission, has a constitutional duty in my respectful submission, has a constitutional duty to give an account of what she has done in the conduct of her responsibilities. Now, my lords, a particular responsibility that she is carrying out and for which she needs to give an account. The particular responsibility here is no less than the responsibility to declare who has, in accordance with the will of the people, been elected the president of Ghana. That is no mean duty. That is a duty in respect of which this petition has been brought. And as I indicated, the issue 2 that your lordships have set down, that issue 2 speaks to the proper conduct of her responsibilities in making a declaration. And this petition is about her own declaration, which we all watched. At least we watched a part of it. And the petition is based on what she said. There has been no other declaration. And your lordships will note that in the affidavit, in the affidavit, again, it's an affidavit that she filed in opposition to a motion on notice for leave to inspect documents, which was another application that we brought. In that affidavit, she states, among other things, in fact, from paragraph 8 of that affidavit, she says, Form 13 is generated from the summation of all the results in the Presidential Regional Results Summary Sheet from 12. The petitioner has duplicated copies of the Presidential Results Summary Sheet from 12 as admitted by the two witnesses of the petitioner. Then paragraph 9, Form 13B was generated by the first respondent to to aid the declaration of results. So, my lord, she is testifying in this affidavit to a number of important facts about what she did. Form 13B was generated by the first respondent to aid the declaration of results obtained by all the candidates by aggregating the results from the presidential regional results summary sheet from 12 for the 16 regions in a way that does not materially affect the form substance and not calculated to mislead any person. Now, my lords, she goes on to say that apart from Form 13, yes, in paragraph 7, she said, I say that save for Forms 13 and 13B, which is attached to my witness statement filed on 22nd January 2021 as Exhibit 4, the petitioner already has in his possession, custody or power, duplicate copies of all the other forms and documents he is requesting to inspect as saved or given to him by his agents at the various courts. So the chairperson, on behalf of the first respondent, is acknowledging that save for Form 13 and 13B, which is attached to the witness statement, petitioner already has certain things in the possession, and she even seeks to quote that Form 13B is a critical form for the exercise of her responsibilities, and she has to speak to that form. Indeed, your lordship's heard testimony from the second witness of the petitioner to the effect that what was being claimed as form, that is Form 13 in CI 127. CI 127 is under the hand of the chairperson of the... After she herself has given a witness statement, then, my lords, with the greatest respect, we would be posing grave dangers to the Republic. Because the holders of important offices can shield themselves from accountability by saying in every case that we will not allow ourselves to be cross-examined, and nobody can do anything about it. And what I submitted earlier, and which ties into this point that I'm making, is that if it were not for the fact that she is the representative who has sworn a witness statement on behalf of the first respondent, it would be open to us to ask the court for a subpoena to have her testify. So, we respectfully submit that in the circumstances that we are faced with here, with this particular holder of this particularly singular office that is supposed to make a determination that reflects the sovereign will of the voters of Ghana in an election, which is what democracy is all about. It is our respectful submission that that constitutional obligation cannot be set aside by subsidiary legislation or by reliance on subsidiary legislation. It cannot. Every legislation that we've talked about, CI 87, CI 47, and I mean, none of that can set aside the sacred public duty of this chairperson and the need to account for that public duty where the forum demands. And my lords, this is a forum that demands it. My lords, reference has been made by my learned friend to the case of Armour versus Hydrofoam. And that was indeed a Supreme Court decision in 2012. The decision read by Justice Baining and a court that comprised various justices, including your Lordship, the Chief Justice. Now, my Lord, that case has absolutely no application to the circumstances that we are dealing with, because in that case, what happened was that the parties had agreed that instead of testifying by themselves, they would both rely on the testimony of an expert, a surveyor. And on appeal, the point was raised that the plaintiff himself ought to have testified and not rely on the evidence of the expert. Within that context, the parties have agreed that we're going to rely on an expert, because this is a matter on which an expert can resolve the issue between us. We don't need to be sort of testifying and, we are not the expert. We'll rely on an expert. The parties have agreed that. Then they go to court, and one party is more or less arguing that because the plaintiff did not testify, it should be held against him. My lords, of course, rejected that argument, and my lords made it clear that you can't compel a party to a suit to testify. My lords, that has nothing to do with the situation that we're dealing with here. And the court said in Baining's judgment, page 1563 to 1564, in the instant case, the issue agreed upon was the value of the land. The trial judge considered it required expert evidence to assist him to determine it. The parties appear to have agreed with that position taken by the trial judge. For apart from the fact that they did not challenge it, neither of them gave evidence by themselves. They all deferred to expert evidence. The plaintiff relied on the evidence of the expert nominated and appointed by the court with the parties' consent. The defendant went further to call three other witnesses, three other experts in land evaluation. It is in that context that the Lordship said a party does not need to call evidence by himself. Where the issue where the issue to be resolved is of such a nature that expert evidence would, I think it should be B, but here it says that, would the best evidence, I think B is missing from the report. Expert evidence would be the best evidence required to assist the tribunal of fact to resolve the issue, or where expert evidence is dispositive of the issue. That is what Armour and Hydrofoam is about. That case has no application to the circumstances that we're dealing with here. The circumstances that we're dealing with here is of somebody who has elected to testify and who has notified of that election not only by submitting a witness statement, but also in affidavits that he has filed. Because, my lord, if we didn't take her affidavit seriously, then it would almost be as if she is taunting us and saying, I I am prepared to give evidence. She's taunting us with that, and she's using that to get a decision in her favor on interrogatories. Once that decision is given, then she now says, no more, I'm not giving evidence. You've said in opposition to an application for leave for interrogatories, you, the holder of that important constitutional office, you said, I am going to be available to be cross-examined. On that basis, among other things, their lordships have made a ruling allowing you not to have to answer interrogatories. Then, after you've got that decision, you now ignore the things that you said in your affidavits, and you come and your counsel is saying to the court, I'm not going to put you in the witness box. Obviously, the interrogatories process that we filed was meant to help us in the conduct of our case. And what they filed by way of witness statements and so on was again meant to help us in the conduct of our case. So once they filed and gave an indication that she was going to testify, and she herself gave that indication in affidavits, my lords, our options in terms of her being called to account for a constitutional duty, our options were entirely non-existent. Our options were to calmly wait for her to come into the witness box for cross-examination. We had no other option. We had no other option, and we still have no other option, because it has not been said at any point to your lordships that they are not relying on that witness statement. It has not been said. Now, my lords, another decision was cited, I believe. Yes, this is the Akunu, Bafo, and Lawrence Boaku case. And my lords, part of the problem that I see in respect of what we are faced with is that on the one hand, they are saying that they are not making a submission of no case. Then on the other hand, they are talking about burden of proof. My lord, the burden of proof can only be relevant if we are talking about a submission of no case. Because otherwise, why are we discussing burden of proof? Burden of proof has no relevance at this point. If all we are talking about is Order 36, Rule 4.3, and so on, burden of proof has absolutely no relevance. In any case, the authority that was cited, this Joseph, Aknu, Bafo, and Lawrence Boaku, significantly, when counsel himself was reading from the passage that he read from, the lordships talked about the shifting of the evidential burden. The shifting of the burden, which depends on the stage that the case is at. And my lord, I'm really reluctant to go into the issue of burden of proof at this point, because I think it's irrelevant. But because it has been raised, I'm obliged to point out why it is irrelevant. Because if your lordships look at the Evidence Act from Section 10, and I will not read those sections, but from Section 10 to Section 15, your lordships will see the differentiation between